Baby, I love you, but the law is my oyster.
There comes a time in a person's life when they need to step back and take a long, hard look at themselves. I had one of those experiences the other day. It all began when I was free for the day, as a big trial was settled on the courthouse steps. I took myself off to the pub. It was still early, well before lunch, and the place was deserted. No customers, just two young students getting a couple of hours' work before the full-time staff came in for the lunch crowd. I sat myself down and looked in the mirror. Jay says, would you look at you? Gray, definitely gray. Not distinguished silver, not statesman-like white. Gray, the color of surrender. Where did the years go? What have I achieved? Sure, my practice is flying, but no wife, no kids. I see my brother and sister at Christmas, and that's just to give presents to their chiselers. What happens when I die? Nobody to get my house, my savings, my car, or my collection of historically important waistcoats. And the electric foot spa, which seemed like an excellent purchase during lockdown. And why is my hair aging faster than the rest of me? I must make a will. Shite, no paper. Could I have a paper napkin, please, pet? Perfect. Civilization has always advanced through necessity. The wheel, the printing press, the testamentary serviette. This is my last will. I leave everything I own to the barmaid who has served me so faithfully this morning. There. Concise, unambiguous, slightly damp. But is it legally valid? Let us begin with the first problem. To keep this objective, I will refer to myself in the third person. Section 77 of the Succession Act 1965 says that, to make a valid will, a person must be at least 18 or fall within the historical marriage provision, and must be of sound disposing mind. That expression does not mean that Declan must be cheerful, sensible, or entirely sober. It means that, at the relevant moment, he must possess testamentary capacity. The Irish courts continue to apply the traditional test derived from Banks versus Goodfellow and adopted in Irish decisions, including in the estate of Brian Radigan. The High Court restated the test clearly in Re Estate of Margaret Bradley in 2025. There are three essential questions. First question, does Declan understand that he is making a will? Second question, does Declan understand what he owns? Third question, can Declan consider the people who might expect to benefit? Let's break those down. First question, does he understand that he is making a will? Does Declan understand the nature of the act and its effect? In plain English, does he realize that he is deciding what will happen to his property after his death? If Declan believes he is writing a drinks order, entering a pub quiz, or nominating the barmaid for Employee of the Month, he does not possess the necessary understanding. But if he knows, this is my will, it will determine who receives my property when I die, then the first part of the test may be satisfied. Second question, does he understand what he owns? Declan does not need to remember the precise balance in every bank account. He does not need to know that his electricity account is €14.72 in credit. But he must understand the general nature and extent of his estate. He should broadly appreciate that he owns a house, savings, a car, furniture, books, and the regrettable foot spa. If he announces that he owns the pub, Waterford Castle, and a controlling interest in Guinness, the pints may have carried him beyond testamentary capacity. Third question, can he consider the people who might expect to benefit? Declan must be able to call to mind the people who might reasonably expect consideration. He has no spouse and no children, but he may have parents, siblings, nieces, nephews, close friends, or other relatives. He is not legally required to leave them anything merely because they are related to him. Parents and siblings do not have the protected legal shares given to a spouse, and Declan has no children who could bring an application under Section 117. Nevertheless, He must be capable of remembering the relevant people and deciding whether to benefit them. He may rationally say, "I have considered my brother. He borrowed my lawnmower in 1998 and has yet to return it. He gets nothing." That may be unkind. It may be petty. It may reveal an extraordinary attachment to garden machinery. But an unkind or eccentric decision is not necessarily an incapable decision. How many pints? And now we reach the evidential elephant in the room. How many pints has Declan consumed? Irish succession law does not have a 3-pint rule. There is no provision saying 1 pint, valid, 2 pints, proceed cautiously, 3 pints, all property passes immediately to the nearest sober relative. Alcohol does not automatically remove testamentary capacity. The question is whether the alcohol actually prevented Declan from satisfying the legal test when he signed the will. Testamentary capacity is a snapshot. In Re Estate of Margaret Bradley, the High Court emphasized that capacity must be examined at the relevant time. A diagnosis such as dementia did not, by itself, prove that the testator lacked capacity when she made her will. The same principle applies to intoxication. Declan may be affected by alcohol, but still understand that he is making a will, what property he broadly owns, which relatives or other people he might consider. Conversely, he might be so intoxicated that he cannot understand the document, remember his property, maintain concentration, or make a settled decision. The 2026 High Court decision in Hogan v. Kears is instructive by analogy. The case involved illness, medication, and addiction rather than a pub will. The court did not treat the consumption of a substance as automatically decisive. It examined its actual effect on the testator. The evidence showed confusion, delirium, difficulty maintaining a conversation, and an inability to call assets and family circumstances to mind. The court found that testamentary capacity was absent. So with Declan, we would examine the evidence. How coherently was he speaking? Could he describe his property? Did he know who his relatives were? Did he understand that the barmaid would receive everything only after his death? Was his handwriting reasonably intelligible? What did the waitress and barmaid observe? What would the CCTV show? And perhaps most ominously, what would the bar tab reveal? The law does not count the pints. It examines the mind. Being merry is not the same as being incapable. Being morbid is not the same as being incapable. And making a decision which your family considers ridiculous is not by itself proof that you lacked capacity. For our story, let us assume that Declan is gloomy and mildly intoxicated, but remains coherent. He understands that he is making a will, knows broadly what he owns, and remembers the relatives whom he has chosen not to benefit. He therefore possesses testamentary capacity. The napkin will survives the first challenge. Now, it must survive the statutory formalities. Section 78 of the Succession Act 1965 sets out the formalities for executing an Irish will. First, the will must be in writing. There is no requirement that it be written on expensive paper. It may be typed or handwritten. Nothing in Section 78 expressly excludes a paper napkin. The napkin is inconvenient, fragile, and likely to absorb stout, but it is capable of carrying writing. Second, Declan must sign at the foot or end of the will. Alternatively, another person may sign for him, provided that person signs in Declan's presence and at his direction. The signature must be intended to give effect to the document as his will. A random autograph written before the testamentary words were added would raise a very different problem. Third, Declan must sign or acknowledge his existing signature in the presence of 2 witnesses who are present at the same time. That simultaneous presence matters. Both must be present together when Declan signs or acknowledges his signature. Fourth, each witness must then sign the will in Declan's presence. The witnesses do not need to read the will. They do not need to approve of its contents. They are witnessing Declan's execution of the document, not endorsing the wisdom of leaving an estate to someone he met beside a Guinness tap. On those assumed facts, the basic requirements of Section 78 appear to have been satisfied. The will is in writing. Declan has signed it at the end. He has signed or acknowledged his signature before two witnesses present together. Each witness has signed in Declan's presence. The will may look absurdly informal. That does not necessarily make it invalid. A magnificent document executed incorrectly may fail. A napkin executed correctly may succeed. But Declan has overlooked one small difficulty. Unfortunately, it is the size of his entire estate. The barmaid is not merely a witness. She is the sole, or at least principal, beneficiary. Declan has left everything to her. Section 82 of the Succession Act 1965 deals directly with this situation. Where a person witnesses the execution of a will, any gift made by that will to the witness or to the witness's spouse is, so far as that person is concerned, utterly null and void. The barmaid's signature does not necessarily invalidate the whole will. It invalidates the gift to her. She may still give evidence proving that Declan properly executed the will. She may be an excellent witness. She is simply a disastrous beneficiary. Even though she faithfully served Declan all those pints, she gets nothing. The rule in Section 82 reduces temptation, suspicion, and disputes. A person who stands to receive the estate should not also provide one of the signatures upon which the validity of that gift depends. It does not matter for Section 82 whether the barmaid acted honestly. It does not matter that the waitress also witnessed the will. It does not matter that Declan genuinely wanted her to inherit. By attesting the will, she destroys her own entitlement. If Declan had chosen two independent witnesses, perhaps the waiter and another customer, the gift to the barmaid could have remained effective, assuming capacity, proper execution, knowledge and approval, and the absence of undue influence. A generous gift to a recently encountered barmaid might attract scrutiny, particularly if she suggested the gift, supplied the wording, isolated Declan from relatives, or pressured him while he was vulnerable. But an unusual gift is not automatically invalid. A person with capacity is generally entitled to make an eccentric, unfair, or surprising will. In our facts, however, we do not need to prove undue influence. Section 82 has already done the work. The barmaid witnessed the will. Her gift is void. If the paper napkin contains no effective alternative beneficiary and the only gift is everything to the barmaid, that gift fails. Declan's estate, or the property left undisposed of, will pass under the statutory rules governing intestacy. Because Declan has never married and has no children, if both parents survive him, they share the estate equally. If only one parent survives, that parent takes the whole estate. If neither parent survives, the estate generally passes to his brothers and sisters, with the statutory rules making provision in certain circumstances for the children of a deceased sibling. If there are no qualifying siblings or their children, more remote next of kin may inherit. Ultimately, if no entitled relative can be found, the state succeeds. So the probable result is wonderfully perverse. Declan intended to exclude his family and enrich the barmaid. The barmaid's signature defeats her gift. The formally executed napkin may remain a will, but its only dispositive provision has collapsed. His relatives may inherit under the intestacy rules after all. Unless, of course, as he is still living, Declan asks for a clean paper napkin and does it all over again, but properly this time. What have we learned from Declan's morning at the pub? First, depression about gray hair does not remove testamentary capacity, nor does drinking alcohol automatically make a person incapable. The court asks whether the testator understood the nature and effect of the will, the general extent of the property, and the people who might reasonably expect consideration. Second, a will can be remarkably informal in appearance. Even a napkin may potentially satisfy the writing requirement. But the execution requirements under Section 78 must be followed carefully: signature, intention, and two properly present witnesses. Third, and most importantly, do not ask your beneficiary to witness the will. The barmaid's signature does not necessarily destroy the entire document. It destroys her gift. A will written in a pub may be valid. A will written after several pints may be valid. A will leaving everything to the barmaid may even be valid. but a will witnessed by the barmaid who receives everything has managed the rare legal achievement of being carefully executed, sincerely intended, and almost completely useless. I am Declan Olula, QC. Make a will, use independent witnesses, and never allow existential anxiety about your hair to dictate the distribution of your estate. This has been The Law is My Oyster. Ah, sure, one for the road.
Baby, I live